distinguish a purely internal provision of law from a conflicts rule or a provision in conflict of laws. A purely internal provision of law governs a domestic problem, one without a foreign element, and it authorizes, commands, or prohibits a certain act or mode of conduct. The question raised, whether the particular act or mode of conduct is allowed, commanded, or prohibited, is immediately solved. Example of an internal rule is Article 796 of the New Civil Code. All persons who are not expressly prohibited by law may make a will. On the other hand, a conflicts rule or provision of law is a provision found in our own law which governs a factual situation possessed of a foreign element. It is usually expressed in the form of an abstract proposition that a given legal question is governed by the law of a particular country, which may be an internal law or the proper foreign law, to be ascertained in the manner indicated by the provision. An example of a conflicts rule is Article 16 of the New Civil Code, which provides that real property, as well as personal property, is subject to the law of the country where it is situated. What are the two kinds of conflicts rules? First, the one-sided rule, which indicates when Philippine law will apply. For example, Article 15 of the New Civil Code provides laws relating to family rights and duties, or the status, condition, and legal capacity of persons are binding upon citizens of the Philippines even though living abroad. Article 818 of the New Civil Code provides two or more persons cannot make a will jointly or in the same instrument, either for their reciprocal benefit or for the benefit of a third person. These provisions apply only to Filipinos. Second, the all-sided or multilateral rule, which indicates whether to apply the local law or the proper foreign law. For example, Article 16 of the New Civil Code provides real property as well as personal property is subject to the law of the country where it is situated. And Article 17 of the New Civil Code provides the forms and solemnities of contracts, wills, and other public instruments shall be governed by the laws of the country in which they are executed. These provisions tell us when to apply Philippine law or the proper foreign law. In the first example, Philippine law is applied if the property is found in the Philippines. If it is found in a foreign country like Japan, Japanese law applies. In the second example, if the contract was executed in the Philippines, its form and solemnities are governed by the Philippine law. If it is executed in a foreign country, say in England, then English law will apply. While Article 15 of the New Civil Code literally applies only to Filipinos and is actually a one-sided rule, the Supreme Court has given it a multilateral application in that it was held that foreigners, in their status and legal capacity, are governed by their national law. In other words, the nationality theory embodied in Article 15 of the New Civil Code has been applied by the Supreme Court even to persons who are citizens of countries following the domiciliary theory like Americans. What are the parts of every conflicts rule? Unlike a purely internal rule, which governs a purely domestic problem without a foreign element, a conflicts rule which indicates whether to apply the internal law or the foreign law has two parts which are readily recognizable. First, the factual situation, or the set of facts or situation presenting a conflicts problem because there is a foreign element involved. Second, the point of contact or connecting factor, which is the law of the country with which the factual situation is mostly intimately connected. In other words, the first part states certain operative facts, the legal consequences of which are determined in the second part. That is, the first part raises while the second part answers or solves a legal question. Example, Article 1763 of the New Civil Code, providing that the law of the country to which the goods are to be transported shall govern the liability of the common carrier for their loss, destruction, or deterioration. In this provision, we have the picture of a cargo ship traveling on the high seas, but for some reason or another, the cargo or part of it is lost, destroyed, or deteriorates during the voyage. What law is to be applied to determine the liability of the ship? Answer: the law of the country to which the lost cargoes are to be transported, or the law of their destination, not the law of the country where the lost cargoes were loaded or the place of embarkation. Another example is Article 1039 of the New Civil Code, providing that capacity to succeed is governed by the law of the nation of the decedent. Here again, we get the picture of a person who dies, but whose heirs may be citizens of another country. What law should apply to determine who will succeed the deceased? Answer: the law says it is the law of the country of which the deceased was a citizen, and not the law of the citizenship of his heirs.